at more common legal myths for you today. So the first one is a permissive counterclaim doesn't need to establish jurisdiction. So these are obviously from Merbeest's reading of Chille's motion for a 60A motion. So I think Merbeest, I don't know, I was given the benefit of the doubt. Maybe he confused permissive and compulsory. But in general, if you file a permissive counterclaim, which is a counterclaim that has to do with facts other than the ones in the plaintiff's complaint against you, then you do have to establish jurisdiction. So that one is not true. You can't get an evidentiary hearing for a Rule 60A motion. Again, it's something that Merbeest said, and that is not true. You just have to request one. As long as there is a question of fact, you'll get one. It would be really weird if you couldn't. So that one is not true. So a non-motion letter that raises an issue is your last chance to raise it. So I guess Chille had written a letter asking the court to rule under 60A, and they didn't. And then Chille filed a motion, and Merbeest says, well, you should have raised these in your letter. You lost the opportunity. So first of all, that's not true. I mean, it's possible that if Chille filed that letter because he's a pro se person, that the clerk might have interpreted it. Well, the court might have interpreted it as a motion, and of course he would have had to have them correct that. But in general, if you send a letter asking or suggesting the court do something on its own, or just giving them the information to do something, make a decision on their own, sua sponte, then, and they don't, you definitely can still file a motion for that. And then not only that, but if your motion is denied, you can file again asking them to reconsider your motion. And then if that's denied, you can ask them to reconsider the judgment on the motion. And then if that's denied, you can appeal the motion. So it's, I don't get what Merbeest was saying there. All right, so there's a lot of other stupid things that Merbeest said about those documents, but maybe those are for another video, because I did want to get this one in here that's kind of timely. So Michael Pierattini has a protection order approved against Chille. So I tried watching Blue Bacon's video, and I couldn't make it past, I think, minute 22, because this guy, I don't know. So first of all, he says he has a protection order approved against Chille, right? And then quotes state law and federal law. And then like a minute later, he says, well, actually, I haven't even filed it. So I don't know. This guy could possibly be a compulsive liar based on what I've seen so far. He might have issue with the truth. But, in general, he's not going to have a protection order that is approved. In general, a guy, it's going to be very difficult, unfortunately, for a guy to get a temporary order, or I should say any type of protection or restraining order before an adversarial hearing. So he doesn't have one. It would be ridiculous if he did. So that's what I got. Have a good one.